Good, even better than ever. Deputy Broughan.
And speak to us.
Thanks, Cahill. And I'd just like to say to my old friend and colleague, Deputy Penrose, I'm glad you're not the barrister in court prosecuting a case against one of the companies of which I'm a director. But at the moment, they're all community companies, so hopefully you wouldn't be doing that. Yeah, but I'm delighted, Cahill, just have it to be able to speak very briefly on the Personal Injuries Assessment Board Amendment Bill number 2, which is before us. It's a really important bill, and the issue, of course, of personal injury claims and insurance costs, there are matters that virtually every week come up with our constituents. And recent reports, of course, show that, as many deputies have said, that the whiplash claims are averaging around €20,000 per claim and account for the vast majority of claims through the Personal Injuries Assessment Board. And, of course, there was 71% of those motor cases in the first half of 2018. The Personal Injuries Commission, of course, under Justice, and we were talking about the judges there as well a minute ago, Justice Nicholas Kearns. I mean, I think it was they who originally informed us, Cahill, that soft tissue compensation awards are 4.5 times the UK level, which is, an extraordinary difference given the, the close connection between the two economies, which we're also worried about, of course, at the moment in the context of Brexit. And of course, it also does highlight the urgent need for the review of the Book of Quantum. And it's extraordinary, of course, that in 2003, look, we didn't put that in the legislation to have regular reviews. Of course, the average Irish soft tissue compensation award is now over €17,000 compared to just €3,984, I think the exact figure in the UK, based on the 2015 to 2017 figures. So this is a huge, huge difference, which for two very similar societies and economies is totally extraordinary. And the bill, of course, has been a long time coming, and follows the Cost of Insurance Working Group report on the cost of motor insurance in January 2017. Like it seemed the government, and of course Deputy McGrath's bill that I'll be just coming back to in last summer, that the government finally had to take action. And the working group was established, of course, following skyrocketing motor insurance premiums that really has caused consternation and outrage among the people who send us to this House. Many of us, of course, Minister, we would have preferred for maybe a more radical solution, and notwithstanding the comments of my colleague Deputy Penrose, that we might begin at some stage to have a look at New Zealand, which I think recently, and as the Minister for Business, that I think New Zealand was number 1. We were fairly high up there as well in ease of doing business, but I think they were number 1 on the planet. But the New Zealand, of course, has the accident compensation scheme, which essentially abolished the notion of fault-based liability for accidental injury. So we didn't get this court system or PIAB system that we have today. But of course the bill amends the Personal Injuries Assessment Board Acts of 2003 and 7 and does strengthen the key remit of the Personal Injuries Assessment Board. The working group recommended that during the PIAB legislation review, and I quote, that cases of non-cooperation such as non-attendance at medicals and refusal to provide details of special damages, end quote, should be assessed. Recommendation 15. It also recommended that the frequency of the Book of Quantum updates be clearly set out in legislation. That was recommendation 19, and of course we had a public consultation on all these matters before us. So the bill before us rightly strengthens the provisions to attend medicals by making the process mandatory effectively. Recommendation 15, of course, is addressed by section 2. Recommendation 15 of the working group is addressed by section 2 of the bill before us, whereby the 2003 Act is amended so that a fee and medical report must be received by the PIAB before a formal notification is issued, and a preliminary notification, of course, may be sent in cases where the fee or medical hasn't been sent into the PIAB, and issues around the lack of clarity and statute of limitations, of course, will be addressed by section 7 of the bill. But the key section, of course, Cahill, is section 8, which provides for the amendment to section 51 of the Principal Act by the insertion of this new 51C to deal with a case of non-compliance with a request by the Board under sections 23 and 24 of the main Act. So where a claimant fails to supply details, so his or her claim for special damages fails to attend a medical exam arranged by PIAB or fails to cooperate with the retained experts, of course the Board must carry out the assessment, and if the claimant rejects this, the Board must release the case and issue authorisation to enable the claimant claimant to proceed to court. But the key sanction contained in Section 8 seems to be the constraint on the subsequent legal costs and, of course, the report of the PAIB itself, whereby the court has discretion to make an order on the costs which will allow the claimant. A key deterrence, of course, for non-compliance is that the court has the discretion to make the order on costs, and Section 8 seems to closely follow the proposals in Section 3 of the Personal Injuries Assessment Board Amendment Bill, introduced, of course, by our colleague Deputy Michael McGrath. And in the case of personal injury, the claimant must also bring a case to court within 2 years. Deputy Penrose referred, of course, to the famous Renahan case, where an issue arose when a new respondent was added to the case who argued that the limitation period had elapsed and therefore the claim was statute barred. So a very welcome provision, Minister, is in Section 9, where the PIAB will have to publish an updated version of the Book of Quantum every 3 years. And of course, the Personal Injuries Board was established by the 2003 Act in order to assess the number of claims going through the court systems and the high awards being granted. And around that time, of course, insurance premiums were increasing rapidly, and the companies blamed expensive court cases and the litigation process. But however, since the establishment of the PAIB, insurance premiums have remained, I think, they're stubbornly high, Minister, and hence this continuous concern this House, which the Finance Committee I know has done when I was formerly a member in the last Dáil, done a lot of work on this and the cost of insurance, that it continues to be a really huge burden on small business, on schools, on clubs and community development bodies, and indeed on every single household and every citizen in the country. I want to, of course, commend Deputy Michael McGrath of Fianna Fáil, who introduced the Personal Injuries Assessment Board Amendment Bill 2018 last June, which I was happy we were happy to study and to look at the key reform, which is echoed, I think is fair to say, isn't it, in the bill in front of us today. Deputy McGrath's bill, of course, tried to address the issue of some claimants using the PIAB simply as a rubber stamp on their way swiftly into the courts. And Deputy McGrath, of course, he put an onus on the main part of his bill on a court hearing a personal injuries case to have regard to the failure of claimants and for respondents to attend a medical examination. And of course, your bill, Minister, does approach the consequences of that failure in a fairly similar way. Since the establishment, the PIAB, of course, must issue the authorisation before a claim can proceed to court, but premiums are still remaining so very, very high. And that's something I think that we've heard again and again and again in this House and in the Finance Committee. 2017, if you look at the figures, this is echoed in the figures, Cathaoirleach. Section 2017 saw just over 33,000 applications to the PIAB and 12,500 awards. That was indeed a reduction in the previous year. The value of 2017 awards, however, was 315 million, and the average time to process claims and awards is reported to have been 7.3 months, just over 7 months. But the highest award was over €600,000 in 2017, but there were 105 awards of more than €100,000. So the majority of awards, of course, were under 20,000, but about a third of the claims seem to go with population, or in the Dublin region, with, say, Cork at 9.6%, Meath and Louth about 4% each. A key element, and again, notwithstanding the speech of my colleague, Deputy Penrose, and I think many of us have raised it, I mean, we keep going back to the cost of litigation. I think the Taoiseach said to me one day on leaders' questions, of course, in relation to another matter, that we were a very litigious people, and we certainly are, but this situation, this consistent situation whereby, and I noticed this again, our excellent library and research staff who provided us again with a very good briefing on this bill, as they do on all key legislation. They highlighted again that former Minister Frank Fahy, Deputy for Galway, when he was the Minister, he said around that time 40% litigation added something like 40% to the cost compensation. It's actually something like 42.5%, I think, at the moment, which is totally unacceptable. So hopefully, and that was the reason, the hope when the PIAB was set up then in 2003, that we'd have a lower and much speedier means of finding finalising genuine personal injury claims, rather than going through this very expensive litigation system. The reviewing of the Book of Quantum, it is very, very welcome, but it still does remind us again of the huge difference with the UK. I know whether your department, Minister, and see you have our colleagues from the department there beside you. if the department, in fact, has over the years really studied the situation, say in Northern Ireland and in the UK, those much less awards, less costly awards, are arrived at there. I know they have a discount rate which they use to assess the cost of future loss, and that discount rate, it's based on these. I think they call them the Ogden tables, actuarial tables, and they look at the cost, Minister. I think over future years, say somebody who has suffered an injury which is life-changing or which impacts on them every day of their lives into the future. And the kind of injuries, in actual fact, that Deputy Penrose again was referring to in cases in citizens that he has represented in the courts. So again, I just wonder if you keep this under review as we go forward with the new legislation, that we again might look at Britain as an exemplar, or perhaps even have a look once and for all at the New Zealand system, and to see would the House have the courage to go straight to that system, because certainly the procedure the UK seems to be in front of us there. And again, my colleague Deputy Penrose, he was talking in relation to the independence of the judges and so on and so forth, and we've had that issue many times, Corlin, a number of issues in this House in relation, for example, to traffic law, how the court system administer the laws that we pass in this House, and Minister Ross is responsible for, and Minister Flanagan at the moment. And it's kind of interesting that there was a recent speech by the Chief Justice, Frank Clark, our Chief Justice, where he actually called on us, to look at legislation, when we were passing legislation, the impact that it would have on future litigation. In other words, if a piece of legislation was something that would be almost provoke litigation in the future, and that we were to examine that. And I questioned, in fact, Deputy Minister Flanagan about that matter, and just replied to the Chief Justice with the reply that I had received. That now the Minister, of course, said that we are constantly, because we have the pre-committee or the pre-legislative stage now, haven't we? Then we've got the committee stage and so on and so forth. But it does seem to me, Minister, that we could use the vast experience of our judiciary, led by Chief Justice Clark, to understand what exactly happens in the courts, and why, in fact, book of quantum seem to be so high, and so much money is spent on litigation. So perhaps that's another thing that might be addressed in the future. I was going to say lastly, or briefly, that it's disappointing, of course, that recommendation 16 of the Cost of Insurance Working Group is not directly addressed in the bill, and we must wait further legislation. Recommendation 16, you might remember, Minister, was to ascertain and set out the measures necessary to implement pre-action protocols for personal injury cases. And there's been some criticism too, I notice, in some of the media in relation to the financial reserves of the PIAB, which at the time, I think in August, when we got that report, would total around 17 million, that it would be, go into the Exchequer. But I think to most of us in this House, it's pretty obvious that that should be the case, that the surplus from PIAB is the people's money, and it certainly should go into the Exchequer. But there wasn't a legislative basis for it, and you're providing that now in section 13 of the bill, Minister. So I want to say again that I warmly welcome the legislation before us. I think it is an important step forward. Again, I commend Deputy McGrath, who first gave us the kind of formula that we might make progress on this, and also the work, indeed, of our colleague here as well, that we would begin to have a process which would be much less costly, less speedy, and which essentially would move towards reducing the incredibly heavy burden on businesses and on households in relation to insurance costs. So thanks, Ken Corlin.